All right, good afternoon, everyone. I'm Judge Morris. You can call me Judge Jan, or you can call me Judge Morris, or you can call me Hey You, whatever you want. It all works for me. Judge Abinanti, are you on?
Oh, I'm sorry. I was waiting for you to start
Okay.
your presentation. I am here,
Right.
and I welcome everybody, and I especially welcome Jerry Hill, who I haven't seen for about 500 years, but more or less.
Right. Looking at the participants, I see a few names that are familiar and a lot of new names. So welcome to all of you. Those who are listening only, welcome to all of you as well. And I also see on the list Judge Moritzen from Walker River, who apparently did not get enough of me last week when I was doing some PA out at his tribal court. So welcome, Judge Aaron. Good to see you here. All right, today we are going to talk about custom, tradition, and culture in tribal courts. And we'll talk about what they are and how we figure those things out, and then how we can use them in our courts. I will probably, my part of the presentation is a little more sterile, a little more legal, talking more about how we would determine custom, tradition, and culture using Western concepts of justice and procedure. Not entirely, but a little bit. And then I'm really counting on Judge Abinanti to kind of fill in some of the blanks. I have a few examples of how I've seen this happen in various tribal courts, and I'm hoping that she has some other examples as well. So with that, we'll get started. I think first off, we have to determine what are custom, tradition, and culture. Now, there is no set definition for any of these terms. I think that most folks would agree that culture describes the entire history and evolution of a population. That culture encompasses the ideas, ideals, and customs of a population. Culture also culture discusses features that describe and define a society. And we need to keep in mind that culture changes continuously. It's not static, it evolves just as that society evolves. Tradition, on the other hand, is the way that things generally have been done over time. Tradition involves the transmission of customs from generation to generation. So sometimes it's storytelling, sometimes it's just mere information, information that's passed from one generation to another, from mother or grandmother or aunt to daughter, granddaughter, or nephew, niece, as well as from uncle or grandfather to grandson or nephew. It's also done through songs and other teachings. But tradition is just the way that we've done things. Tradition can also change to meet the evolution of our societal cultures. Custom, if we had three hands, custom on the third hand would be social norms, what are considered as acceptable behavior in our communities. It is the standard of proper social behavior. And customs also often carry penalties for non-compliance. So if you violate the social norms of a society, you should be aware of, and you should expect to experience any types of penalties for any non-compliance in that community. So let's compare and contrast these terms a little bit, and I'll hopefully this will show you maybe what we're talking about here. culture, when we're talking about the culture of a tribal society, we may be talking about something as important as a young woman's coming-of-age ceremony. The tradition involved with that cultural aspect will describe when it occurs. So not only does it describe when it occurs in the lifespan of the young woman, but also the time of year or the season in which these types of ceremonies typically would occur. Tradition will also describe who helps prepare, who is responsible for preparing the site, preparing any lodges or other buildings or facilities, who's responsible for helping the young woman prepare, what types of clothing is worn, and what types of adornment or painting is involved. Those are all things that have to do with the traditions of the coming-of-age ceremony. The custom for those types of ceremonies describes the social norms for those types of events, including that, people should maintain sobriety in those things and show respect and reverence to the traditions and to the culture and to the young woman herself. In what contexts are we likely to consider culture, tradition, and custom in a tribal court? Well, probably the place that I've seen it myself personally most often is in probate. But you will also find custom and tradition or culture involved in domestic relations cases, very often with tribes in criminal sentencing, and also traditional dispute resolution. As a practical matter, when, if ever, does a tribal court consider culture, tradition, and custom? So when do we take, as judges, as fact finders, when do we consider those things? Well, as with any court system, and especially American court systems, upon which tribes have very often modeled their justice systems, our first source of law is always going to be the tribal constitution. So let's look at a couple of examples of constitutional authority with regard to the importance of custom and tradition in those communities. The Yavapai Constitution, with the Yavapai tribe in northwest Arizona, states, "We, the members of the Yavapai Indian tribe, do hereby adopt this Constitution in order to govern ourselves under our own laws and customs for the common good and well-being of the tribe and its members." So you can see that the Yavapai leaders felt that custom and tradition and tribal laws were paramount governance of their society, of their tribe. Another example comes from the Fort McDowell Yavapai Nation, whose constitution reads, "We, the people of the Fort McDowell Yavapai Nation, in order to improve, promote, and maintain our culture, customs, and independence of our people, do ordain and establish this Constitution for the Fort McDowell Yavapai Nation." Again, a very clear example of just how important culture and customs are in that community. After the Constitution, then we will look to other sources of authority, particularly judges will, see how or when we need to apply custom and tradition. Again, from the Yavapai Law and Order Code, we see that in the application of law, first level is in many matters before it, the tribal court shall consider or shall apply the written law as follows: the tribal constitution, codes, ordinances, and resolutions of the tribe, including this law and order code. And in matters not addressed by the written law, the tribal court shall apply traditional tribal customs and usages, which shall be called the tribal common law. Again, a very clear indication to judges of the community that it's not something that you can or should apply, but if there is no written law, there's nothing in the codes or tribal resolutions or ordinances, then the judge must apply traditional tribal customs. From the Fort McDowell Yavapai Nation Law and Order Code, in all actions before the courts of the Fort McDowell Yavapai Nation, the law of the Fort McDowell Nation shall be controlling. The law of the community consists of the Law and Order Code and the common law of the nation. The common law is composed of both the customary law of the community and the rules of law and decisions of the tribal court. Again, very clear statutory direction to judges about the use of customary law. Let me give you a couple of examples that I have experienced in my years on the bench. And this one's a little complicated. I'll try to simplify it and keep it short. Judge Morrison already heard this last week. There was a situation when I was with the Yavapai tribe where there was two tribal members, husband and wife, both elders, the wife being from a very traditional Yavapai family. They lived just off the reservation, but still had significant contacts with the community. The wife was in poor health and eventually passed away. The husband was going to make arrangements, and in fact had made arrangements through the funeral home to have a Christian ceremony at a particular place on the reservation and to have his wife buried in a particular cemetery that he believes is where she wanted to be. However, the couple's adult daughter wanted to make sure, because the wife had been of a very traditional family, wanted to make sure that her passing was handled in a traditional way, with traditional services and a burial in the traditional cemetery used by that family, which was different than the one desired by the husband. The daughter filed a petition in the tribal court for an injunction stopping the father from his burial plans for the wife. The petition was filed on Tuesday. The burial and services were scheduled on Friday. So we made quick arrangements to hold an evidentiary hearing on Thursday of that week. We sent out notices to everyone and had them personally delivered to make sure that everyone would be present, and because there was not sufficient time to issue subpoenas for witnesses, the parties were advised to bring their own witnesses with them with regard to the custom and traditions of the tribe. The hearing took place that Thursday. Oral testimony was taken from the husband, from the father, who described his reasons for wanting the Christian services and burial in a particular cemetery, which again he believed were his wife's last wishes. And the daughter then, the petitioner, brought forth, I believe there were about 6 witnesses who testified. Some were relatives and some were known traditional people within the community, all of them describing independently how the custom of the tribe was that female relatives of a decedent were responsible for making the arrangements for their passing into the next life. Because there was essentially very, very equal consensus among all of the petitioners, and in consideration of the requirements of the Yavapai Constitution and ordinances, I was required to make a finding about which type of services the woman would receive. Under Arizona, and this is in Arizona, under Arizona law there is a statute that sets a hierarchy of people who can determine what to do with a deceased person's body. And the first level is always the individual spouse, if they have a spouse that survives them. But nothing in Yavapai law allowed me to incorporate Arizona law, but it did require me to apply traditional law. And so I had to find in favor of the daughter that it was the female relatives who needed to make the arrangements to have a traditional service and to have the woman buried in the family's traditional cemetery. And it was very difficult for me, I can tell you, to make that decision and look the husband in the eye and basically tell him that he could not have his wife buried where he wanted her to be. And I retired to my chambers to write the order. And when I came back out 20 minutes later, the parties had reached an agreement that they would combine the services, that they would have a Christian services prior to the traditional services, which start at 6 p.m. and go until 6 a.m. the next morning, and then followed by burial in the family's traditional cemetery. So there was an agreement reached between them. But there's an example of where I had to find and utilize custom and tradition because the law was silent on those issues. Another really quick example, again, came from the passing of an elder in the Fort McDowell Yavapai Nation in Arizona. The gentleman, a widower, passed away. His adult children were scattered on the reservation and off the reservation. They came together to determine what to do with the gentleman and his belongings, and they decided to use traditional Yavapai custom, and that is to place the individual and all of his belongings in his lodge or his dwelling place, and to set the place on fire and to burn everything up. Well, the real problem with that is that it was a HUD house. It belonged to the Housing Authority, and obviously it would have resulted in charges of arson to anyone who destroyed that house by setting it on fire. So again, we held a hearing and we made a plan to basically they would take all of his belongings and put them outside in a pile outside, and they would burn his belongings on his property without including the house. So had to make some compromise on that one, but there was still some application of tribal tradition and custom. Judge Abinanti, I don't know if you have any examples that you want to share, or if anyone from the class has anything that they would like to share. If you want to raise your hand or notify Jessica that you have something to share, that would be great.
I'm not sure if anyone from the class does.
Doesn't appear so.
All right, then I think I'll give a couple of examples too. We, in our court, have worked really hard to set up a situation where people feel comfortable participating in the whatever dispute that they're having, that they can represent themselves. So oftentimes when people come in, I'll say to them, do you want to have a discussion and see if we can resolve this? Do you want a trial? What would you like to do? And probably 99 out of 100 people will say, we just want to talk about it, Judge, and see what we can figure out. And so that's pretty much how we proceed. And that is essentially how our disputes are resolved throughout time. And what we concentrate on is looking at our value system, how what we value in community, and then developing practices that work for today. So, for instance, fishing is a big deal here, and the offenses will range from minor infractions to larger problems. An example would be leaving your net in beyond the time that you're supposed to remove it. So if I have people come in and say, okay, well, you left your net in past 8:30 and we seized your net and your fish, and now, how do you want to plead? And they say, well, we don't want to plead, we just want to tell you what happened. Okay, what happened? Well, I left my net in because I forgot to charge my cell phone and I didn't wake up. And I'm like, well, that's kind of dumb. So why don't you pay, the first fine is $100, but there is a dance this weekend. So instead, if you agree to take 2 fish to the dance, I'll return your net to you. And the fisherman said, okay, I can do that. I go to the next one. I said, well, how come you left your net in too long? And he said, well, because that first guy is my cousin, and he was supposed to go help Auntie get her net out, and she couldn't find him. So I went to help her instead. Well, clearly, even though the law says you're supposed to have it at 8:30, the value is that you should have helped your auntie before you looked to your own needs. So I said, okay, well, I'm going to just return your net because you did the right thing, regardless of what the law is. And then the first guy says, okay, he was fine with that. And he said, well, how do you know that I'm going to take the fish there? And I said, well, you're in here because you're not smart enough to charge your cell phone, not because you're a liar. So I have to assume that you will. And he said, yeah, I will. I just wondered. And I said, okay, well, that works. I said, because in the first place, I'll be at the dance, and if you don't, I'll know. And you don't want to face me on Monday morning if you haven't, so it'll work. So, we do a lot of that kind of thing. Look at, okay, here's the law, here's the act that you did, and here's the value, and what value are we trying to instill. And in that situation, yes, we want the nets out at a certain time, but clearly it's important that you look to your aunt before you look to your own needs, because I know she's elderly and she needed the help. Or, she could have got hurt trying to get her net out. So we do a lot of that kind of work with people. And pretty much even on very serious disputes, it's much like that. It's a discussion. What are we going to do? How are we going to resolve this? If I feel like it's a purely cultural issue, I might send them out to talk to somebody. I mean, an example would be we had 2 guys I issued a restraining order because they were going at it on the river over a fishing hole. And so they both came in and I said, okay, what are you guys doing? And, they were both clearly mad. I said, look, this fishing hole dispute is something that should have been resolved with a cultural leader. I said, I issued restraining orders because I couldn't trust that you 2 knuckleheads wouldn't, kill each other, which I can't fix. So we have a cultural leader who works for the court in another role. I want you guys to all walk out of here and see if you can resolve it. I said, because it's really what we would call a men's camp issue, and you need to resolve it. And I really don't want to. I will, but I don't want to. And so they left, and a couple hours later they came back and said, don't worry, Judge, it's all taken care of. And they were happy, and I was happy. So it's really trying to remind people what our values are, who they should be going to when they have certain kinds of disputes, which belong in front of me and which don't, and trying to get people back into the value system and the community value system. And that's a lot of the work that we do is around that, is trying to go, okay, this is what we're going to do. This is how we're going to do it.
Right, very good. And I think that emphasizes one of the key features that our tribal courts provide in our communities, I think, and that is that it is a safe and neutral environment where people can actually get together and hopefully get rid of some of the feelings and animosity and get down to the meat of the issues and discuss them civilly between themselves.
Well, yeah, before, I feel like, we always had that, and even with our criminal disputes, when we take guys who are, I've had people who are working on their third strike, and we get them out of jail, we work with them for a couple of years, and sort of re-socialize them into the community and into the community's value system. Because when they've spent too much time in an environment that isn't really supportive of our values, then they don't know what to do. And you can ask somebody, why did you do that? And when they look back at you, you have a clear sense that they have no idea why they did that. And so you have to help them figure out why they did it and then a way around it. And I think our domestic violence program is a good example of that. We had our victims advocacy program, then we decided to do a perpetrator program, and I got our probation officers certified to deliver the state certified program, which is a 52-week program, because a lot of them were getting arrested by the state and not completing the program. And we teach them all the things they're supposed to learn in the state system, but we also redid the curriculum to have a cultural component, because I said, I want us to understand where violence came into the culture, because this is not who we are or who we ever were. And you need to understand in your family, we've had massacres here, we've had children indentured as slaves, and we had the boarding schools. Somehow violence came into your family, and I want you to interview all the elders that you can find and figure out where it came into your family so you know how it got there. And then we can start talking about how we're going to get it out of there. And then they start going, oh, okay, I get it. I get how this happened. And that's how you get, instead of going, well, historical trauma in general, you go historical trauma in specific, and how did it impact me and my family and what I'm doing and my behavior.
Very excellent examples. Thank you, Judge Abinanti.
Mm-hmm.
So sometimes in a more formal type of setting in our tribal courts, it's going to be up to the tribal judge to determine what culture, tradition, and custom are, how they can be established, what sources will be used to do that, and how and if they should be applied. Very often, well, not very often, sometimes, such as myself, you will have a judge who is not from the community that they serve or not from a related tribal group. And so we come in not necessarily knowing what the local customs and traditions are. We certainly endeavor to learn them as much as we can, and as Judge Abinanti described, try to implement those processes within our systems to make them more meaningful to the community. But we have to become familiar with those customs and traditions. And there are certain sources that we can use. Information that's proffered by the parties or by a party. Again, it could be information that they bring based on their own knowledge of their community and their social structure. You might use what I guess we could term as expert witnesses providing testimony, and that would be tribal elders and other traditional leaders of the community who would come in and describe their qualifications for knowing what they know and discussing what they can discuss. Or if your tribe or the tribe for which you work has a cultural department, there may be individuals within that department who have the information or can obtain the information that you would need in court to find what the culture, the tradition, or the custom is. The American Bureau of Ethnology conducted a number of studies from probably the early 1800s, 1830s, until probably about 100 years later, the 1930s. And there were a number of ethnologic or ethnographic studies that were done among the tribes around the country. And if you can go back and find all of that old information, there's a lot of description about tribal communities and their culture and their customs and that could be a very good source because it was very immediate at a time when culture and tradition were still very much in place in most tribal communities. There may be some sources from university research, again, sociological or behavioral studies that have been done through some sort of a university program that may be useful. If also, I have actually found some old newspaper clippings from a particular area in a particular point in time, usually the late 1800s, early 1900s, that how reliable it is, you don't know, but it does describe certain things or certain customs that were apparent among the native peoples of that area. So just a few different types of sources that you can look at. It doesn't mean to describe what to do with that information in a moment. When you're qualifying these experts, when you have these local traditional leaders who are saying, yes, I know what the custom, I know what the tradition is within our society, how do you qualify that individual as an expert? Sometimes we have to do it very carefully. When I was at Yavapai, the Yavapai tribe consists of 2,400 enrolled people, probably about 2,500 now. But historically, the tribe was comprised of 15 different bands. And as we are aware, most of us, different clans and tribal society don't always view everything the same way. And so you don't want to qualify an expert who may be affiliated with one particular band or clan to speak on the custom and tradition of the whole tribe or of a different band. So those are types of things that you may need to inquire about if you're going to qualify that individual as an expert. And Judge Abinanti, again, or the class, does anyone else have any examples of how those intra-tribal differences can be important in determining what culture and custom are?
I guess I've pretty much taken the position at this point is that I will help other people, from neighboring tribes if they call me and say, what do you think, or how do you think we should approach this, or, then I'll help them think it through, but that I don't really feel qualified myself to go and tell or make a ruling on somebody else's culture. So I won't, but I think that's a sort of limited position. My preference is to say, look, give me somebody that you all agree to, and I will teach them how to negotiate being a judge or, maneuver through that. That I feel like I can do. But as far as saying to somebody, this is what I think, your choices ought to be, I don't feel comfortable doing that at this point. So I don't. But I see what you're saying in the sense of, if you get called in to do that, I think that's, those are approaches. And I think every tribe has to decide what they want to do. And some people feel comfortable with that. And that's fine, and a good way to proceed. I don't have any problem with other people doing it. I just can't do it.
Right.
So.
Right. And it again, kind of highlights the differences. There
Right.
are regional differences around the country. You've got the Northwest, you've got the Southwest, you've got the Plains tribes, the Great Lakes tribes, the tribes in the Southeast. In those regional areas, very often you see within those regional areas tribes that have very similar practices, even though they're
Right.
not exactly the same. But there again, you have the differences from the Southeast to the Northwest. And even though they may both rely on water, either rivers or oceans or lakes, there are completely different cultures and traditions involved with that. So it's really kind of difficult. You just have to go with what you can find locally to get that specific information. Again, receiving the evidence about what custom or tradition is. You have the testimony of witnesses, documents, again, talking about studies or other things that you can find, any type of physical evidence that you might have. I know in the Gila River Indian community and the Salt River Indian community comprised of Pima and Maricopa peoples, there was a historical practice among the Pimas or the Otham people to create a calendar stick. And there was an individual who was responsible for maintaining that calendar stick, and in that calendar stick would be carved certain symbols or representations of events that took place during a year, such that the stick could be used as a history book. And the individual in charge of maintaining that stick could look at the symbols and recite the history of the tribe doing that. That's where the term talking stick, if you're familiar with the Talking Stick Resort in Salt River, that's where the talking stick reference comes from, and that's what it was called, the talking stick. That's physical evidence that could be representative of, in conjunction with testimony of the keeper. There are 3 R's of evidence. Is that evidence reliable? Is it relevant? Is it reliable? And what is the rightness? Is it right to allow that evidence in? Does it seem fair and relevant and reliable to come in? And so if you meet those 3 R's, I'm not exactly sure that it matters where the evidence comes from. And regardless of whether you let it in or not, there are, let me go here first and then I'll come back to the other slide. The finder of fact, whether it's the judge or the jury, will then determine the credibility of the witnesses and give weight to the evidence, including testimony. So even if you admit certain testimony, regardless of its source, it is still going to be up to you to determine whether or not the person offering that evidence is credible and how much weight you should give to that. And of course, it's always important to identify those credibility and weight issues on the record when you make your oral pronouncement of the case. If you're relying on those things, make sure you announce those on the record. And it's always best if you can include it in your written decision as well. I do want to caution you on one thing. Let's go back to this slide. If there is a possibility that whatever court order that is going to emanate from your hearing and decision of a particular case, if there is any potential that that could go before a federal court for review, the federal courts have certain rules, and among them the rules of evidence, and particularly the rule regarding hearsay. And pretty much universally, the federal courts have ruled that lay witness oral tradition evidence is considered hearsay. So what is very compelling, what we find to be very compelling in our tribal courts and our tribal systems and our tribal communities is only considered a myth or legend, and therefore is unreliable and is considered hearsay in the federal courts. There have been a couple of exceptions, and they're very narrow, and they don't apply to very many cases. Some oral tradition evidence may be admissible as a hearsay exception pursuant to Evidence Rule 803, and I'm not going to go into details. You can look those up. Or otherwise, oral tradition evidence could possibly be admitted through an expert witness pursuant to Rule 702. So if you want to take a look at those and look up some case law that goes with that, just so you're aware that it shouldn't stop you or change what you're doing in your tribal court when you're making findings or rulings on custom and tradition. Just be aware that if there's a possibility of that issue going before a federal court for review, they are going to look at it differently than we do, just so you're aware of that. So,
Judge Dan,
yes.
There's been a comment in chat. Have you looked at the Canadian jurisprudence for your oral histories? And then she cites some examples here, and accepting oral history as evidence. Is that something you've heard about?
I have not heard about it, and I have not looked at it. Judge Abinanti may be more familiar with that, but again, because that is on the other side of our country's northern border with the First Nations, I know that the relationships between the First Nations and the Canadian governments is a bit different than we have here, and even though we have many of the same tribal groups along the border and points further north, they are not considered Indians under our federal system in the United States, and so even if I could find those cases and talk about the jurisprudence or try to rely on the jurisprudence, Canadian jurisprudence regarding that oral history, it will probably carry very little weight in a United States federal court. But since you did raise the issue, I think it's something I'm going to have to look into because it sounds very interesting.
And I guess my approach on stuff like this is to go, I understand that that's their rule, and it's not the first time in my life that I have found them to be wrong. And I would look at arguments, new arguments to get around that. They are fraught with error, and part of what we have to do is try to come up with, I think, different and new arguments, and I think the Canadian one is a good one. And I think that, we have to sort of step back and not just go head-to-head with them, but look at, okay, what's the way around this? What's the way? Because we have strong reasons for looking to our culture and to those precepts. And I think we have to articulate them, hopefully in a way that will make them take a different kind of look at it. They have, on occasion, come to their senses, and, we have to help them the best we can.
Yeah, certainly I agree with that. And it kind of points, I guess, maybe to a concept that I have, and that is that, it seems to me on the whole that the American concept, the American justice system is centered around administering legal justice. But I think as tribal people in our tribal justice systems, I think we have an obligation to determine what is tribal justice.
Right.
Tribal justice should obviously incorporate any of the legal authorities, whether it's the Constitution, the Tribal Code, or anything else that is required of us to do, but tribal justice sometimes doesn't fit the model or the mold of American legal justice, and that's what we're there for. We're there for our communities, and if I allow evidence or testimony in oral tradition testimony or anything else in order to make a decision on my tribal court case, I'm going to do that regardless of what I think the feds do. So, Judge Abinanti, I know you kind of discussed this briefly, but could you give us maybe a little more detail or direction with regards to how you believe that we can create more culturally relevant courts in our tribal communities?
Well, part of it was, for us was even in the structure of the courtroom. The interior of my courtroom looks like sort of the evolution of what our homes would have looked like. It's small. I don't have a built-up bench. I have tables that we sit at, and when the tables are all pushed together, there's 5 separate tables. Inlaid on the top of the table is the Klamath River, which is our main river. And on the front of each one of those tables is the river with river rocks from our river, so that when you walk in, you get a sense, oh, okay, this is what we're doing. We all sit at the same level. I don't wear a robe because I think a lot of our people here really associate courts with negative experiences, and I want them not to do that. I want them to really see us as, and what we work at in our court with all of our personnel is becoming members of their extended family. So a lot of our work and our advocates and the people who support the court system are really support system people. So that our child support, we do outreach, we have visitation, we show them how to do online parenting classes. We've set up a system whereby, okay, you owe child support, but if you all are in agreement, you can give other things besides money for child support. That can be wood, it can be fish, it can be meat, it can be whatever, and if both sides are in agreement, that's what we'll accept. So that we do a lot of those kinds of things. We work on, okay, you have this problem and you are kind of wrecked right now. Maybe you need to go to treatment. Do you want us to help you get into treatment? Because we'll help you do that, and we can settle this other matter later. So we do a lot of that kind of thing. We help people clean up their records so they can get employment. We help, all sorts of things like that. So what we're teaching most of the staff here is, I'll say, okay, we have formal training for probation officers, formal training for advocates, all that. But we also have, okay, what is your value system? And here, discipline and support was really sort of an aunt and uncle role. So it's, okay, if you're out in the field and something happens and you need to think about what to do, think about what you would do and default into your aunt and uncle position and do what you would do as an aunt and uncle, and you're going to be fine. And that's what we're trying to work toward constantly, is you do that. We don't have the separation by, if I know you or I don't know you. It's really about, you have to try to come to a solution. And when I first came home, people were like, well, you can't be our judge because you know this person. I'm like, you knuckleheads, I know everybody, and you all know me. We all grew up together. Of course we know each other. They have a system of justice by strangers, and that's fine. That works for them. They have a right to choose whatever they want. That was never our way. We lived in small villages, and when we had issues, we had people in the village that we would go to. That's what this is. That's how we're going to proceed. And if you need help, you come to your village first and you get that help. That's what I'm supposed to do, is provide the help, not just go, okay, well, wait till I can catch you and then you're going to get it. That's not helpful. When people get arrested or put in jail, we try to visit them right away, see what their options are. Can we help you? How should we go forward? Are you ready to go into treatment now? Not go into treatment? What do you need? How are we going to do this? How are we going to go forward? Because when you get out, we're all going to be in the same place. We all live together. We have to figure this out. And a lot of what we do is that. And that's consistent with our values. And I get, that we had an invasion and we had a lot of behavior that came from that invasion that's not good. And so our practices have to be different than our practices of 200 years ago, but our values are not different. And that's what we're changing, is how do we deal with that? Clearly 200 years ago, we were not dealing with heroin, we were not dealing with meth, we were not dealing with a system that pumped up a bunch of pills into our community. So there's a lot of things that we didn't have to deal with then. But the value systems can cover that. So you have to go, okay, what are the practices? And the practices do not include, well, we're not going to give you any social services help till we catch you abusing somebody. I mean, that doesn't make any sense. Maybe we should go, if you come in and ask for help, we're going to give it to you. And this is how we're going to do it. Or if we see something, go up to you and go, it looks like you need help. Here's what we have to offer. What do you think? And so we're changing into that process, which is consistent with who we were as people. And I think we're getting better results. And we're getting people who are able to walk away from a bad lifestyle choices. And that's what, I'm most interested in.
And I think in the vast majority of cases, those types of values and those types of practices are not going to be reviewed by anybody, probably not
Right.
even a tribal appellate system, let alone the feds or anyone else. It's simply restoring our community values and sense of justice to what they used to be. We need to, because the American, so many, we could go through the whole history of the IRA constitutions and why tribal courts were developed the way they were with the assistance of the Bureau of Indian Affairs of the federal government. But let's face it, the American jurisprudence, the American justice system is based on controversy, and that's not how we have done things. It's inconsistent with our tribal values from the beginning. And so now, to the extent that we can get back to those values, and those values can then guide and inform our court practices, then that creates that substantial tribal justice that I talked about. And I think that's really what our responsibility is, and what the responsibility of our tribal court forums is as well.
No, I agree, and I think it's really a matter of trying to adjust that and work through that, because having spent several years on the bench in San Francisco, I have a pretty good working knowledge of both systems. And I have to say that a lot of people are not particularly happy with their system, meaning the state system, because they're finding that it's just not working for them either. So I'm more interested in something that gives a person a chance to come back into community.
Excellent. Well, I think that pretty much concludes what we had to offer, unless Judge Abinanti wants to offer anything else in addition.
I don't think so. I think we've punished them enough.
Well, that's what I'm thinking. It's probably they're tired of listening to me anyway. So. Are there any
you guys are very patient.
Or comments or any other discussion that any of the participants would like to engage in, or even afterwards, if you can just notify NAICJA and they can forward that information if you want to keep it on the down low and have a little one-on-one. I know, speaking for myself, you can always use me as a network contact if you think I have information that may be useful to you, then please feel free to get in touch with me. And Judge Abinanti, I think, is much the same way.
Yeah, and I will forward you to him, so that's fine.
Right.
I figured out how to do that. So, all right.
It does look like we did get one question. The question is, are states amenable to transferring criminal cases to tribal courts? What do you guys think about that?
Well, for me, what I've done is I've often waited until, or we've set up a system where they have jurisdiction and they make a finding of guilt or innocence, and then I'll go up and say, well, can I have this person for a year or two? And if they work with me and they show all these different signposts of rehabilitation, will you look at reducing the sentence or reducing the felony to a misdemeanor? And we've been very successful with that. Because one thing about living in a small community is you have judges who have been sentencing somebody since they were 8 years old, and now they're on their third strike, and everything they've ever tried has never worked. So they're like, what the heck, let her try, And the more successful you are about that, they're not unhappy with that either, because they don't like having spent their entire life doing something that didn't work.
Right. I would have to say I don't think that I'm familiar with any particular area in any particular state where that happens on a sometimes or a regular basis.
Well,
but
now you are.
To me, that there are some areas, probably the more rural areas or the less populated areas of certain states, and because they're in those counties or those areas, their state resources are just as limited as our tribal resources.
Exactly.
And if their penalties or their resolution of that case are going to cost them those resources, whereas if they can come back to the tribal community, not only are you helping the individual, but you're also utilizing resources that may not cost you anything. So I could certainly see some benefit to that happening in certain areas, and maybe so, possibly so up in Alaska. I think it may be moving kind of that way a little bit up there.
Okay, we good?
You think so?
Okay. Well, thank you, everyone. Have a good rest of your day.
And Rebekah, did you want to close this out?
Yes. Thank you, Judge Abinanti and Judge Morris, for that very interesting and informative presentation. Before we conclude, I just wanted to take a moment to talk about NAICJA and our work in tribal communities. NAICJA is a tribal justice professional organization whose goal is to build tribal court capacity. We do a pretty broad range of work for tribal communities, including training and technical assistance to support tribal courts. We're also TA providers for the Bureau of Justice Assistance, CTAS Purpose Area 3 grantees. I know I probably met a few of you last week in Palm Springs. Another part of our work is the Tribal Access to Justice Innovation website. This website allows us to highlight and share different programs in tribal communities. If you know of a promising program, let us know about it. And if it's not already highlighted on our website, we can go ahead and share it. That website is tribaljustice.org. And again, our goal with it is to learn about emerging practices and share that information, as many tribes are addressing common challenges. Part of our support for tribal courts is also our webinar, our free webinar opportunities, which are monthly, with the exception of this month. As you know, we're offering this double header. Today we had incorporating cultural practices into your tribal court. On December 19th, again, same times, 1:30 Pacific, 2:30 Mountain, 3:30 Central, and 4:30 Eastern Standard Time, we will have building tribal court capacity. This session will explore how tribal courts can build and enhance their capacity to serve their community. Faculty will discuss the basics of court management and how to develop programs to support the legal work of the court. Faculty will also address how the development of court programs can allow for involvement of the community and tribal membership in the tribal court and enhance relationships between the court, community, and the membership it serves. And that concludes our webinar. My email address is Rebekah, REBEKAH, at NAICJA, NAICJA.org. If anyone has any questions or technical or training assistance requests, please email. Otherwise, thank you to our presenters again for your presentation, and NCJFCJ for hosting, and thank you everyone for joining us today.
And Rebekah, I just want to chime in. The webinar next week actually is starting an hour earlier than you announced. We're starting at 12:30 p.m. Pacific and 3:30 Eastern. So that's
well, I'll be sure to update. Okay, perfect.
Yeah.
Thank you.
All right. Thanks, everybody.
Thank you all.